Hey guys, tonight we trudge through the thick fog of Victorian London, where the smell of damp cobblestones mingles with the ever-present scent of coal smoke and overcooked cabbage. You wrap your scarf tight around your neck, your breath clouding the chill air, as you pass under flickering gas lamps that seem to sputter and hiss in protest at the gloom swallowing the streets. You hear the distant clatter of carriage wheels, the clack of polished boots, and, if you listen carefully, the soft, almost pitiful sound of a gentleman cursing under his breath. Why? Because he's lost his hat. And not just any hat. Mind you, a top hat, meticulously brushed, carefully perched, and socially essential. And in this corner of the 19th century, losing a hat was no small inconvenience. It was a social disaster of the highest, most sleepily absurd order. You'd be surprised how many poor souls marched into courtrooms demanding justice for their missing, squashed, or brace yourself stolen hats. Of course, you probably won't survive this deep dive into the sleepy world of Victorian hat-related court cases. Not because it's dangerous, oh no, but because the sheer, droning absurdity of the lawsuits we're about to explore might just lull you into the deepest, most velvety slumber of your life. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. And while you're at it, why not post your location and local time down in the comments? I'd love to see where and when you're listening in from. Now, dim the lights, maybe turn on a fan for that soft background hum. Let's ease into tonight's journey together. You wander into Fleet Street, where the gaslight flickers against windows filled with wanted posters, bakery ads, and the occasional caricature of a gentleman chasing his airborne hat. You feel the drizzle dampening your coat, the city's fog swallowing your footsteps, as you join a small crowd gathered outside a courthouse where an unusually passionate trial is underway. Inside, the courtroom hums with the murmurs of London's finest, as a certain Mr. Percival Higginbotham takes the stand. His face is flushed with outrage, and his voice trembles with the gravity of his grievance. His silk top hat, he claims, was stolen right off his head by a rogue in Piccadilly Circus. A hat he describes, in perhaps more detail than necessary, as a mark of civility, a crown upon which the dignity of a man's station is proclaimed to the world. You stifle a yawn as the court clerk scribbles every florid adjective into the ledger. Historians still argue whether these courts took hat cases seriously out of genuine concern for property rights or if, much like yourself right now, they were just desperately bored and looking for entertainment. Some suggest that hats in Victorian London were more than fashion statements, they were fragile emblems of class hierarchy, and losing one publicly could be social suicide. Of course, the more cynical side of you suspects the courts enjoyed these sleepy spectacles, dragging them on longer than necessary. The more absurd the complaint, the more colorful the testimonies, the better the stories to share over Luquanti. And oh, the testimonies. Witness after witness steps forward. The cab driver who saw the hat fly into the gutter, the street sweeper who insists it was the work of a known hat snatcher gang, and your favorite, the baker's apprentice who claims the hat sprouted wings and flapped off into the night. The judge, whose robe is slightly askew from what you guess was an interrupted nap, listens with an expression of utter disinterest. He strokes his sideburns, sighs dramatically, and mutters something about yet another hat case. You settle into a creaky bench at the back of the courtroom, letting the droning legalese wash over you like a soft drizzle. You can't help but smile at the sleepy absurdity of it all. The lost hat, once perched proudly atop Mr. Higginbotham's carefully coiffed head, is now the star of a legal drama so dull, so meandering, you feel your eyelids growing heavier by the minute. But don't drift off just yet. There are far more curious hat cases awaiting you in these foggy streets, and the sleepy justice of Victorian London is only just getting started. You slouch deeper into your seat as the trial trudges on, the courtroom's oil lamps casting a dull, flickering glow that does little to invigorate the audience or the magistrate. The air feels thick, heavy with the scent of damp wool and ink, and the gentle scratch of the clerk's quill becomes the sleepy soundtrack to this unfolding hat opera. Tonight's absurdity stars the infamous 1864 case of the silk hat scandal at St. James's Park. You lean forward as the prosecutor, a weary man with an unfortunate mustache that seems to wag along with his arguments, presents the case to the court. According to the records, is certain Mr. Alastair Plumpley accused a street performer's monkey of absconding with his hat during a lively Sunday stroll. Yes, a monkey. And yes, the hat was described as always in painstaking, almost poetically ridiculous detail. Black silk, brushed to a mere shine, with a burgundy velvet band imported, allegedly, from Paris. The theft, Mr. Plumpley argued, was not just a petty crime, but a direct affront to his dignity, his station, and if you believed his dramatic Western civilization itself. Historians still argue whether this case reflected a society overly obsessed with appearances, or whether Victorian London's courts simply indulged these grievances as a kind of civic theatre. Some scholars suggest the hat, at this point in history, had transcended mere accessory status. It was now a symbol of everything the Victorians feared losing: order, propriety, and their tenuous grip on a rapidly changing world. You, however, suspect the judges just enjoyed seeing monkeys in the courtroom. Indeed, the star witness, a capuchin monkey named Lord Bumble, sat on the defense table, occasionally gnawing at a peanut while his handler pleaded the beast's innocence. The judge, fighting a yawn, asked the jury to disregard the monkey's hat, which it still stubbornly wore during proceedings, much to the jury's amusement. The courtroom dissolved into sleepy chaos as Lord Bumbles was paraded before the court, the monkey blinking lazily under the velvet-banded top hat, its expression unreadable. The defense argued the hat had been gifted to the monkey by Mr. Plumpley's own careless tipping gesture. The plaintiff, meanwhile, clutched his remaining garments and demanded punitive damages, emotional compensation, and, curiously, a new hat this time with a reinforced chin strap. Witnesses bickered over whether the monkey had indeed climbed Mr. Plumpley's head or if the hat had merely fallen victim to the Sunday wind. One elderly woman, her voice as thin as her bonnet's ribbon, insisted she saw the monkey tip the hat mockingly before screwing up a lamppost. Another claimed the hat had been possessed by evil spirits, and that the monkey, in fact, was the hero of the day. You rub your temples. The courtroom is thick with tales, theories, and the kind of sleep-inducing drama that only Victorian London could turn into a 4-hour legal slog. The judge rubbed his eyes, the jury shuffled uncomfortably, and the monkey scratched itself in ways you'd rather not describe. In the end, the verdict was as anticlimactic as the proceedings. The court ruled in favor of the monkey, or rather, against the plaintiff, citing a lack of credible human witnesses and an overabundance of melodrama. Mr. Plumpley stormed from the courthouse, heedless, his dignity trailing behind him like a frayed coat hem. And you let the warm haze of the courtroom lull you deeper into its sleepy absurdity. These trials weren't about winning or losing. They were about the performance, the ritual, the slow dance of etiquette and ego that lulled Londoners into the belief that, even in a city bursting at the seams with poverty, disease, and rats the size of dachshunds, justice would still make time for a hat. The clerk called the next case. Another hat, another gentleman, another yawning jury. You chuckle softly, letting the droning voices and the scent of damp vellum rock you into a gentler state of dreamy bemusement. And outside, beyond the courtroom's heavy oak doors, the fog rolled on, swallowing the city's gaslights, its shadows, and its endless parade of toppled toppers. You shuffle outside into the misty night, your boots sloshing through puddles that gleam like pools of melted pewter under the dim gaslights. The city hums softly around you, carriages rattle, Footsteps echo down alleyways, and somewhere a street preacher shouts warnings of doom, though even he sounds a little sleepy tonight. You meander toward the more affluent districts, where the hats grow taller, shinier, and some might argue more pompous. And it's here that the peculiar intersection of hats and social standing turns into a simmering cauldron of absurd courtroom disputes. You find yourself in the company of two gentlemen engaged in a heated debate over the relative merits of felt versus silk. Their voices rise over the clatter of hoofbeats, drawing the attention of passing constables. Before you know it, you're swept into another courtroom drama, this one centered not on theft, but on insult. The year was 1872, and the case of Mr. Reginald Featherstone versus Lord Henry Pickett became the talk of every coffeehouse from Soho to South Kensington. The offense: Lord Pickett, in an act of unforgivable social defiance, allegedly called Mr. Featherstone's hat provincial at a garden party. Yes, provincial. You lean against the courtroom wall as Mr. Featherstone recounts his humiliation, his face crimson with both outrage and perhaps just a touch of theatrical flair. He describes the gasp of the gathered guests, the snickers of the ladies under their frilly bonnets, and the way his hat, once proudly perched, seemed to droop under the weight of public ridicule. Historians still argue whether this case was a rare example of Victorian courts dipping into matters of honor or merely an exaggerated spat between two bored aristocrats. Some suggest that the case reflects the rigid class anxieties of the time, where a hat was more than headgear. It was a battleground for respect, authority, and that all-important social pecking order. You, however, can't help but notice the sleepy absurdity of the court proceedings. The judge, struggling to maintain composure, listens as witnesses describe the exact phrasing, the tone, even the tilt of Lord Pickett's head when the alleged insult was uttered. One lady insists the sneer was subtle but unmistakable. Another claims she saw the hat in question and can confirm it was, indeed, tragically unfashionable. The court spent no less than 3 days debating whether calling a hat provincial constituted actionable slander. Expert milliners were summoned to testify on the hat's style, origin, and its social acceptability within London's fashionable circles. One of them, a weary man in pince-nez glasses, declared under oath that the hat may have been suitable for a modest solicitor in Bath, but certainly not for the ballroom at Buckingham. You feel the corners of your mouth tug upward in a sleepy grin. It's hard to take any of this seriously, but the court certainly does. The jury, tasked with this grave decision, deliberated for hours, arguing over the nuances of Victorian hat etiquette. In the end, the court ruled that while Lord Pickett's remark was undoubtedly impolite, it fell short of legal slander. Mr. Featherstone left the courtroom red-faced, while Lord Pickett sauntered out, hat tipped smugly, no doubt already drafting invitations to his next, even snobbier garden party. You drift through the gallery, letting the echoes of that sleepy trial lull you into a soft fog of bemusement. These cases weren't just about hats, they were reflections of a society teetering on the edge of self-parody, where appearances mattered so much that even the smallest slight could trigger legal melodrama. And as the courtroom emptied, the gaslights flickered, and the city yawned, you couldn't help but feel the weight of 1,000 forgotten hat cases drifting like top hats in the Thames. Their stories waiting to rock sleepy listeners like yourself into the gentlest, silliest of slumbers. The next morning finds you trudging through the maze of narrow alleys behind Covent Garden, where the smell of damp will mingle with roasted chestnuts and the lingering perfume of yesterday's courtier. You shuffle past hat shops displaying elaborate creations in windows glazed with condensation, each hat perched on a dummy head like a proud soldier awaiting duty. And yet, for every hat perched safely on a head or a mannequin, there were those that found themselves victims of theft, misplacement, or, more bizarrely, elaborate schemes of hat fraud. You step inside the courtroom just in time to catch the case of the Crown versus Timothy Farthing, a notorious figure known in the tabloids as the Rogue of Regent Street. His crime, masterfully swapping worn-out hats for new ones at hat shops across London, leaving bewildered shopkeepers clutching empty hat boxes or worse still old hats with ink stains and suspicious remarks. Mr. Farthing stands proudly in the dock, wearing a stolen hat, of course, his expression somewhere between smug and sleepy. The prosecutor, red in the face and practically frothing at the mouth, accuses him of undermining the sacred art of millinery trade. Farthing's defense: a hat's a hat. Who's to say which head it belongs on once it's out in the world? Historians still argue whether Victorian London's courts were truly invested in stopping such petty hat thieves, or if they secretly enjoyed these cases as theatrical interludes from the monotony of tax disputes and sewage complaints. There's evidence that many of these trials drew larger crowds than political debates, perhaps because everyone, from chimney sweeps to duchesses, feared losing their hats to roguish charmers like Farthing. The testimonies roll on, delivered with the same slow cadence as a wearied town crier. Shopkeepers describe Farthing's tactics, charming the clerk, asking to see the most expensive hats, claiming the lighting was poor, and, in the confusion, swapping hats faster than a magician pulling rabbits. One shop girl, with cheeks flushed from equal parts anger and embarrassment, admitted she didn't realize the switch until Farthing tipped his old hat at her on his way out. You let the slow rhythm of the trial seep into your bones, feeling the soft hum of the courtroom snoozing spectators, the droning of lawyers, the crackle of the judge's wax seal being pressed onto yet another yawn-inducing warrant. In one particularly sleepy moment, the defense lawyer presents a so-called hat confusion chart, attempting to show that, given the vast similarity among black toppers in London, no one could be truly certain if their hat was theirs unless they wrote their name inside it in indelible ink. The courtroom bursts into muffled laughter, and even the judge smirks before remembering himself and sternly tapping his gavel. The verdict: guilty, of course, but with a punishment so light you suspect even the judge was too bored to dream up something harsher. Farthing is fined a modest sum and sent on his way, undoubtedly to pluck another unsuspecting gentleman's hat before tea time. You wander back into the streets, the fog curling round your boots, your thoughts drifting as lazily as the court's verdict. Victorian London, it seems, was a place where even the theft of something as trivial as a hat could become a drowsy spectacle of law and order, where the machinery of justice turns slowly, creaking like an old carriage wool through puddles of social snobbery and legal pedantry. And you let yourself sink deeper into that cozy absurdity, the sleepy comfort of a world where the worst crime you might face on a foggy morning is a switched hat, and the sleepy trial that follows is more soothing than a lullaby. You shuffle onto the worn timbers of Victoria Station's bustling platform, where the air buzzes with steam, soot, and the echoes of clipped conversations from London's most punctual commuters. Hats bob above the crowd like drifting boats on a choppy river of tightly buttoned coats and hurrying footsteps. You pull your scarf tighter as a gust of damp wind lifts a gentleman's topper skyward, setting off a chorus of gasps. It's here, on these platforms of steel and steam, that the next curious chapter of London's hat courtroom dramas unfolds. The 1878 case of Briggs versus Howland and Sons Railway Company was one of the more peculiar spectacles in the city's legal archives. The complaint: a hat, of course, more specifically, a silk topper that Mr. Briggs insisted was snatched clean off his head by a malicious breeze, sent whirling down the tracks where it met a tragic, and dignified and beneath the wheels of the 420 to Paddington. Mr. Briggs, undeterred by laughter from railway staff, sued the railway company for negligence, claiming they failed to protect passengers and their precious headgear from the treacheries of Platform G. USTS. Historians still debate whether this case reflected a city overrun by legal trivialities or whether it represented genuine anxieties of a public court between the old world of cobbled streets and the roaring rival of the modern industrial age. Hats after all, were struggling to maintain their dominance in a world where trains, telegraphs, and electricity were shoving their way into daily life, toppling old traditions along with lost hats. The trial, much to your delight, dragged on for days, drawing crowds eager for a courtroom drama lighter than the grim tax cases clogging the docks. Witnesses debated the velocity of railway winds. Experts argued over hat aerodynamics. One engineer presented a chart showing how certain brim angles made hats more vulnerable to platform uplift. The court, in a particularly soporific moment, even endured a live demonstration of hat safety straps, though the models fell asleep waiting for the judge's verdict. But the real drama came when Mr. Briggs produced his ruined hat as exhibit a crumpled, soot-streaked thing that looked less like a symbol of gentlemanly refinement and more like the aftermath of a particularly bad stew. The jury, stifling giggles, examined the evidence with all the solemnity they could muster. Mr. Briggs, growing ever more theatrical, argued that no gentleman should be subjected to such humiliation. Imagine, he cried, writhing hateless at a dinner party, forced to explain to your host that you were bested not by man, nor beast, but by the cruel whims of an unsympathetic railway company. You can't help but smile at the sleepy absurdity of it all. The judge, known for his fondness of legal puns, finally ruled against Mr. Briggs, declaring the case blown out of proportion and noting, with a smirk, that gentlemen concerned about such hazards should invest in sturdier hatpins. Mr. Briggs left the courtroom in a huff, though not before attempting to bill the railway company for the cost of his replacement hat. Along with the dry cleaning of his coat and attempt, the court dismissed with a weary wave of the gavel. As the courtroom emptied once more into the fog, you drift alongside the other sleepy spectators, letting the murmurs of yet another hat dispute fade into the city's familiar hum. And somewhere, far beyond the courtroom walls, the trains still rolled on, the platforms still swirled with mischievous winds, and London's hats, ever dignified and ever doomed, continued their precarious dance atop the heads of the city's anxious commuters. You find yourself wandering now into the bustling arcades and alleys near Charing Cross, where shopkeepers hawk their wares beneath striped awnings, and the air is thick with the scent of fresh ink from penny newspapers promising tales of scandal and spectacle. And it's here that one of London's most peculiar courtroom curiosities unfolded, not over a hat lost or stolen, but over a case of mistaken identity, or, as the court ledger dryly put it, the case of the confused umbrella and the borrowed hat. It started in 1883, on a particularly drizzly Tuesday, when Mr. Leopold Wainwright entered the bustling lobby of St. James's Club, shook the raindrops from his coat, and retrieved what he believed to be his hat and umbrella from the crowded vestibule. Only they weren't his. The mix-up might have been settled with a muttered apology, but Mr. Wainwright, ever the proud barrister, wore the hat into court, where it was recognized loudly and with theatrical indignation by its actual owner, Mr. Percival Butterfield, a man known for his distinctive hat band embroidered with tiny hunting hounds. The resulting legal battle was the stuff of Victorian and penny dreadful dreams. Wainwright was accused not just of theft, but of publicly parading round in another man's hat, thereby tarnishing the hat's social standing. Yes, the hat's standing, not just the man's. Historians still argue whether this case highlighted the period's obsession with personal property rights or whether it was, simply, an elaborate excuse for two bored gentlemen to air their grievances in the most sleepily melodramatic way possible. Either way, the court was packed to the rafters with gawkers eager to witness the absurdity. The proceedings stretched over a week, filled with testimonies from hatters, doormen, and even an elderly lady who claimed to have recognized the hat in question during a rainy promenade by the Thames. The defense argued that the umbrella's similarity caused the confusion, suggesting that any gentleman could be forgiven for mistaking his accessories after a damp commute. The plaintiff, however, insisted that no man of breeding would mistake a hat adorned with such distinctive embroidery. To hammer home his point, he paraded the hat round the courtroom, prompting the judge to remark that, while the hat was certainly striking, it was perhaps not worth the collective loss of London's working hours over the matter. You, reclining sleepily on the back bench, let the droning lawyer soothe you into a foggy haze. You couldn't help but smile as the clerk read aloud the list of previous hat misappropriations brought before the court, some intentional, some not, all equally absurd. One fringe tidbit from the case sticks in your mind. The public outcry in Fleet Street, where satirical cartoonists mocked the trial by illustrating Londoners wearing nameplates on their hats, while mischievous umbrellas lurked in alleyways like pickpockets. The newspapers milked the trial for every drop of sleepy scandal, and Londoners, ever fond of a legal circus, bought extra copies just to chuckle over their morning tea. The court, in the end, ruled the event a case of unfortunate confusion, dismissing the theft charges but fining Wainwright for a carelessness unbecoming of a barrister. The judge, ever the sleep-deprived showman, delivered his closing remarks with a smirk, suggesting that perhaps gentlemen should begin monogramming their hats with more visible letters, or, better still, simply watch where they placed their belongings. The case faded into history, but the sleepy lessons remained. Even in the bustling heart of London, a misplaced hat could send ripples through courts, newspapers, and polite drawing rooms, reminding everyone that, in the end, hats were never just hats. They were theater, and as the trial faded into memory, you found yourself slipping deeper into the cozy comfort of the absurd, letting the hum of legalese and the clatter of rain on cobblestones rock you into that delicious, drowsy space where London's courts hummed on slow, absurd, and ever so soothing. The drizzling city pulls you toward Cheapside, where the hats grow wider, the shopkeepers sharper, and the tales of courtroom absurdity fluffier than the feathered bonnets displayed in milliner's window. W.S. It is here that a most peculiar courtroom chapter unfolded, known in legal folklore as the Great Milliner Testimony of 1885. You wander into the courtroom just in time to see Madame Eloise Beaufort take the stand, a milliner of such renown that she was known in both Paris and London as the Duchess of Feathers, She arrives swathed in teal and saffron, her towering bonnet a riot of exotic plumes, daring curls, and what may or may not be a taxidermied hummingbird perched atop a silk bough. Her task, to testify in a case where a gentleman, Sir Clement Ashbury, claimed he had been sold a counterfeit hat by an unscrupulous dealer. The hat in question, his stately stovepipe model, had collapsed in the rain, much to Sir Clement's humiliation. Now, he sought to bring the might of British justice upon the hatmaker responsible. Historians still argue whether this case was a serious attempt to root out counterfeit millinery or a sleepy sideshow meant to distract Londoners from the city's more pressing issues, like sanitation or labor strikes. You suspect the latter. After all, when the newspapers dedicated more column inches to hat integrity than to Parliament's latest squabbles, you know you're drifting in cozy absurdity. The court listened, half dozing, as Madame Beaufort delivered her expert opinion on the hat's fabric, stitching, and structure. She declared the hat an abomination, citing inferior linings and what she termed vulgar glue. The courtroom gasped, and you stifled a chuckle. Only in Victorian London, you thought, would a courtroom gasp over vulgar glue. Sir Clement's lawyer produced a dizzying array of charts comparing the disputed hat's dimensions to those of an authentic stovepipe model. He even introduced a water bucket for a live demonstration of the hat's collapse, prompting more laughter than legal gravitas. Madame Beaufort, unfazed, described the art of proper hat-making as a sacred craft, one she compared without a hint of irony to cathedral architecture. She explained how every curve, every feather, every stitch contributed not only to the wearer's dignity, but to the moral fabric of society itself. You let her words wash over you like a soft drizzle, the courtroom sleepy murmurs lulling you into the kind of foggy trance only Victorian hat trials could inspire. But the case took an even more drowsy turn when the defense produced Mr. Biddle, an elderly porter from the hat shop, who testified that the hat in question had, in fact, been left too close to a coal stove, an environmental hazard not covered under warranty. The jury, now thoroughly bored and slightly soothed by the testimony's plodding pace, leaned heavily toward a verdict of shared fault. In the end, the court ruled that Sir Clement bore partial responsibility for the hat's demise, though the shop was fined a modest sum for selling a hat that failed to meet the standards of London's L.I.T. fog resilience. You sigh contentedly as the court emptied, the gentle scrape of chairs and the sleepy chatter of the galley serving as your lullaby. These trials weren't about hats, not really. They were about maintaining the fragile, frilly dance of propriety in a world spinning faster with industry and change. And if that meant dragging a bonnet into court for forensic scrutiny, so be it. Madame Beaufort left the court to rapturous applause from the ladies in the gallery, her hat bobbing like a ship on a gentle sea. And you drifted out into the mist, the memory of her feathered testimony brushing softly against the edges of your mind, lulling you deeper into the sleepy, soothing absurdity of London's hat-obsessed justice. The fog thickens as you shuffle along the damp avenues toward the East End, where the hats were fewer, the bonnets plainer, but the legal disputes just as sleepily absurd. Here, in the maze of cobbled streets and flickering lamplight, you stumble upon a case that teetered between public nuisance and private insult all over a hat. It was the case of Hollingsworth versus the Lamb's Head Tavern, a sleepy dispute that began with a trampled felt hat and ended with the town's finest arguing whether the hat's demise constituted a pobble, icy hazard, or a personal affront. You settle into the courtroom as the plaintiff. Mr. Hollingsworth, a weary clerk with a flair for dramatic gestures, lays out his grievance in painstaking, sleep-inducing detail. According to him, his hat was not merely stepped upon during a crowded evening at the Lamb's Head, but maliciously thrown onto the floor by a drunken patron. The defense, naturally, insisted the hat was left in the middle of the tavern's entrance, an invitation for accidental trembling, to which Hollingsworth responded with an indignant huff, claiming that no gentleman would leave his hat so carelessly, unless he intended to challenge the decency of the entire establishment. Historians still argue whether Victorian courts truly entertained such cases out of duty or simply out of a fondness for the kind of gently meandering theatre that kept London's clerks and clerics distracted from the city's harsher realities. Some suggest these trials served as public catharsis, allowing aggrieved gentlemen to reclaim their dignity under the sleepy eye of the law. The trial dragged on for days, each side producing character witnesses, most of whom couldn't quite recall if the hat had been knocked down, tossed, or, as one elderly regular testified, perhaps it leapt onto the floor of its own will. You smirk into your scarf as the court indulged a heated debate over whether hats, when left in doorways, became public hazards. One lawyer, sleepily inventive, argued that hats could be classed as stationary trespassers, invoking obscure municipal laws usually reserved for runaway livestock. The judge, perhaps half napping behind his spectacles, allowed the argument, prompting the courtroom clerk to scribble down hat, potential nuisance object, into the docket. Of course, the real absurdity came when the defense wheeled in a wax mannequin wearing a replica of the disputed hat, positioning it dramatically in the tavern's entrance while jurors were encouraged to walk past it, testing whether they, too, would trip. The demonstration, as you might expect, led to more giggles than enlightenment. In the end, the court ruled in favor of the tavern, declaring the hat's placement recklessly inviting of its own destruction. The judge, now thoroughly tired of hats in general, issued a closing remark that has since become legendary among sleepy courtroom historians. Let it be known that hats belong upon heads or upon hooks. Nowhere else shall they find sympathy in this court. The gallery erupted in polite applause. The bailiff yawned behind his mustache, and you drifted into the streets once more, letting the fog soak into your coat as the sleepy logic of London's court settled over you like a wool blanket. You can't help but feel a sleepy fondness for this world, where even a flattened felt hat could summon the machinery of justice, dragging everyone into a slow, soothing spiral of etiquette, dignity, and the endless, droning pursuit of order in a city where even the hats misbehaved. And as the courthouse doors creaked shut behind you, you whispered a quiet thank you to the hat, now immortalized in court records and sleepy tales. Its brief, absurd moment in the spotlight, forever part of London's drowsiest legal legends. Your weary boots take you toward the financial heart of the city, where the hats grow darker, taller, and more suffocatingly respectable. But even here, amid the polished marble foyers and brass-lettered doors, hats stirred sleepy courtroom debates. You find yourself leaning against a marble column outside the office of Gray and Butterworth Insurance Ltd., where today's case is unfolding not over theft, but over the peculiar world of hat insurance. Yes, you heard right. Victorian Londoners, ever anxious to shield their dignity along with their skulls, had begun insuring their most precious toppers. And as with all things insurance, the sleepy squabbles that ensued were nothing short of soothingly ridiculous. The case of Penrose versus Bray and Butterworth was a sleepy spectacle from the start. Mr. Penrose, a solicitor with an unfortunate limp and an even more unfortunate fondness for tall tales, was suing his insurer for denying his claim over a ruined beaver felt hat. The cause? According to Penrose, the hat was assaulted by a rogue street urchin armed with a pigeon. Historians still debate whether this case reflects the period's overindulgence in bureaucratic nonsense or the more charming human desire to protect everything, including one's dignity, from the unpredictable mischief of the city's streets. The trial certainly blurred the line between farce and finance. You slump onto a bench in the courtroom's echoing hall, the gaslight casting sleepy shadows over the assembled crowd. Penrose, with no shortage of flair, described the attack in dramatic detail. The pigeon, he claimed, had been flung at him by the boy, colliding squarely with his beloved hat, leaving it crumpled, stained, and reeking of bird. The insurer's lawyer, droning like a lullaby, argued that while theft and accidental damage were covered, assault by foul was a gray area, falling outside the defined hazards in the policy. The court listened to an endless parade of expert witnesses. Ornithologists debated the force required for a pigeon to collapse a hat. Insurance clerks read aloud obscure clauses that seemed crafted specifically to induce yawns. The judge, whose patience was as thin as his own hat's brim, scrawled doodles of birds in the margins of his notes, occasionally lifting his eyes to mutter, "Proceed," though heaven knows why. One curious tidbit from the trial remains a favorite among sleepy historians. To demonstrate the damage, the defense staged a courtroom experiment with a taxidermied pigeon, which they hurled at a selection of hats, sending the gallery into stifled giggles, and the judge into what might generously be called a theatrical sigh. In the end, the court sided with the insurer, ruling that while unfortunate, Mr. Penrose's hat had fallen victim to avian misconduct, a risk not explicitly protected under the terms of his policy. The courtroom, half asleep by this point, murmured approval, and Mr. Penrose, dejected but still hateless, shuffled home. You chuckle softly as the court emptied, your breath fogging the chilled air as you stepped back into the streets. There was something soothing about these trials, where the absurdity of a pigeon-wielding street urchin could derail London's finest legal minds into days of sleepy debate. You wandered into a small coffee house, sipping weak tea as the city's latest hat scandal was dissected in hushed tones. And as the fog rolled in once more, blanketing the city in its sleepy embrace, you let the gentle absurdity of it all rock you into a deeper, softer fog of your own. Because in Victorian London, even insurance couldn't protect you from the comforting absurdity of a pigeon, a toppled hat, and the slow, soothing churn of a courtroom lulled into gentle, pointless ceremony. You find yourself drifting now into the gentler streets of Bloomsbury, where bonneted ladies parade under parasols and the disputes of the day take on a softer, though no less sleepy, flair. For in this genteel corner of Victorian London, the hat disputes weren't about silk toppers or stovepipes, but about the delicate world of ladies' bonnets and the courtroom chaos they somehow managed to inspire. The year was 1887, and the case of Lady Constance Smethwick versus the Grand Emporium of Millinery unfolded like a doily-draped melodrama. You squeeze into the back of the courtroom as Lady Constance, armed with a bonnet that could double as a small sailing vessel, took the stand. A complaint, the bonnet, purchased for an afternoon garden promenade, had collapsed into a soggy mess during a sudden rainstorm, prompting her to sue the milliner for gross misrepresentation of bonnet durability. Historians still squabble over whether this case reflected the era's gendered anxieties where women's fashion collided with the rigid expectations of public decorum, or if it was merely a sleepy satire of consumer rights gone whimsically, of course. You suspect both. After all, a courtroom had never seen so many bonnets in one place, and the gallery, filled with society's finest ladies, whispered furiously as the milliner's defense unfurled a parade of counter-arguments. The defense argued that bonnets, by nature, were decorative attire, never intended for inclement weather, and that any woman of refinement would have known better than to risk a bonnet in London drizzle. This prompted a flurry of fan-flicking and gasps from the gallery, some ladies clutching their own bonnets as if fearing they, too, might crumble under scrutiny. A curious moment came when the judge, perhaps a little too eager to understand the bonnet's failings, asked for a demonstration. Lady Constance obliged, placing the now famously floppy bonnet upon a mannequin, then pouring a jug of water over it. The courtroom gasped as the bonnet sagged like an overcooked pudding. The judge scribbled a sleepy note, murmuring something about bonnet resilience under duress. Witnesses took the stand, including society ladies who attested to the bonnet's betrayal and one particularly brave gentleman who admitted he had declined to accompany Lady Constance that day for fear the bonnet might cause a scene. The court erupted in giggles, the gallery fanning themselves with sleepy delight. But the case took a more drowsy turn when the milliner produced records showing the bonnet was advertised as ornamental, and nowhere did it claim to withstand weather of biblical proportions. The jury, now visibly slouching in their seats, found themselves presented with stacks of bonnet catalogues, each featuring frothy descriptions more suited to poetry than practicality. The verdict: the court ruled in favor of the milliner, though not without a gentle warning to all millinery shops to temper their florid descriptions, lest they find themselves drowning in bonnet disputes. Lady Constance, suitably offended, declared she would never again set foot in the Emporium, to which the defense lawyer, perhaps feeling the sleepy weight of the proceedings, murmured, "We should all be so lucky." You drifted from the courtroom, the scent of lavender sachets and damp silk trailing behind you, the sleepy echoes of bonnet justice ringing gently in your ears. And as the gaslights flickered against the velvet sky, you found yourself wondering how many more hats, bonnets, and toppers London's courts could possibly endure. The answer, you suspected, was endless. For as long as Londoners wore hats, they would find new and sleepier ways to squabble over them. By now, you've learned that Victorian London's hat disputes could worm their sleepy way into even the most personal of spaces. And nowhere was that more evident than in the quietly absurd, deeply tragic, yet somehow soothingly ridiculous case of Babington versus Smythe, known to the papers as the friendship that died beneath a hat. You ambled toward the court on a drizzly autumn morning, your boots echoing in puddles as you imagine the scene you're about to witness. To gentlemen, Once the closest of friends, now standing on opposite sides of the courtroom, their friendship squashed quite literally by a flattened hat. The facts were simple if you squinted at them sideways. Mr. Babington and Mr. Smythe, lifelong friends, shared a leisurely stroll through Kensington Gardens when a gust of wind, or perhaps a playful shove the accounts vary, caused Babington's hat to fall. Smythe, ever the joker, stepped on the hat in jest. But Babington, a man of delicate sensibilities and an unusually strong attachment to his beaver felt topper, did not laugh. No, Babington filed suit. Historians still argue whether this case represented a genuine rift of the soul or was merely an elaborate social drama staged to nurse wounded pride under the sleepy gaze of the court. You, pressed into a corner of the gallery, suspect it was both and neither. Because only in London could such a petty grievance unravel into weeks of droning testimony, diagrams, and sighing judges. The court, now a little too practiced in hat-related grievances, listened warily as Babington described the incident in fluent prose, claiming the squashed had symbolized the squashing of their brotherhood. Smythe, meanwhile, rolled his eyes, which the papers noted in detail, insisting the gesture was playful, no more offensive than a friendly nudge. And yet, the hat told a different story. Babington presented the crashed, misshapen artifact in court, placing it upon the evidence table like a wounded soldier returned from battle. The jury, as ever, examined it with sleepy curiosity, one juror even donning the hat, much to the judge's chagrin, prompting an immediate scolding and the phrase, "This is not a theatre, sir." The defense, desperate to inject a bit of humor into the increasingly soggy proceedings, called character witnesses who testified to Smythe's lifelong habit of harmless pranks, ice cubes down collars, exaggerated mustache drawings in the margins of legal papers, and, most famously, the Great Goose incident of 1880, to which the court wisely declined to revisit. But Babington was unmoved. His testimony stretched on for hours, each sentence dripping with the gravity of lost trust, ending with his now famous line, "A hat may be mended, but a friendship, once trampled, cannot." The gallery, perhaps lulled into a hypnotic trance by his melancholy cadence, sighed as one. The verdict, when it came, was as drowsy as the trial itself. The court ruled in favor of Babington, awarding him the cost of a replacement hat plus a token sum for emotional distress. The friendship, however, was beyond the court's reach. You drift from the courtroom, the muffled sobs of a friendship lost mingling with the rain, feeling the sleepy weight of a world where even the squashing of a hat could collapse bonds forged over decade. And yet, there's something oddly comforting in the way the court handled it all with slow decorum, heavy sighs, and the gentle, predictable rhythms of Victorian justice. Because even when hearts were bruised and hats were crushed, the sleepy machinery of law rolled on, soothing, absurd, and as soft as the drizzle now pattering on your hat's brim. Your path now winds into the quieter residential lanes of Marylebone, where the clatter of carriages gives way to the soft clip of polished boots and the murmur of gossip floating from behind velvet doctor. 8 windows. Here, the hats were subtler, the disputes more delicate, but no less drenched in sleepy absurdity. The courtroom hums with gentle disapproval as you slip inside for the next case, asterisk the curious matter of the misjudged tip, asterisk. It was a case that only London's courts could stretch into a 3-day yawning debate. The plaintiff, Mr. Algernon Peabody, had accused Mr. Lionel Griggs of an unforgivable breach of etiquette, tipping his hat in an insufficient and discourteous manner during a social encounter outside Hatchett's bookshop. You blink slowly as the details are laid bare. According to Peabody, Griggs's tip was barely perceptible, lacking flourish and suggestive of condescension rather than camaraderie. The court, visibly struggling to stifle its yawns, listened as Peabody described the traumatic impact of such a slight social humiliation, whispers from onlookers, and a ruined appetite for the rest of the afternoon. Historians still debate whether this case reflected the Victorian obsession with manners or whether it was simply another example of Londoners weaponizing the courts to soothe bruised egos. Some suggest that in an era where every gesture could make or break one's standing, even the humble hat tip became a sleepy battleground for propriety. Briggs, for his part, appears baffled as the jury, insisting his tip was entirely appropriate given the weather, the time of day, and the relative closeness of their acquaintance. His lawyer produced a chart, yes, an actual chart detailing the accepted angles of hat tipping based on various social situations, complete with delicate watercolor illustrations. The gallery giggled. The judge rubbed his temples, and you let the soft rhythm of the trial pull you deeper into its cozy fog. The plaintiff then introduced character witnesses, ladies from his bridge club, who testified that the tip was indeed cold, perfunctory, and utterly lacking the swooping elegance expected of a gentleman on Bond Street. The defense retaliated with a parade of doormen, footmen, and a particularly animated lamplighter, all of whom defended Briggs's tipping form as adequate and within the sleepy bounds of decency. But the true high point of the case came when the court clerk was asked to demonstrate the alleged offensive tip. The poor man, cheeks flushed, performed a half-hearted gesture with a battered bowler, prompting such snickers from the gallery that the judge banged his gavel with what might have been his loudest yaw. And yet, in the end, the court ruled in favor of Briggs, though not without issuing a sleepy reminder to all present that while the law might not punish half-hearted hat tips, society's cold stare surely would. You drift from the courtroom, the soft echoes of etiquette clashing against the fog of a city forever tangled in its own sleepy rituals. You find comfort in the predictability of it all, the way Victorian London clung to its hats, its manners, its slow, droning sense of order, using the courts not so much to punish, but to rock themselves gently into the comforting illusion that every slight, every squashed hat, every misjudged tip could be set right. And as you meander back into the lamplit streets, you feel your own hat tip forward on your brow, the sleepy weight of the city pressing against your shoulders, urging you ever deeper into its drowsy embrace. Your boots carry you into the stately corridors of the Old Bailey, where the more serious cases of fraud, theft, and treason unfold. And yet, even within these stone walls heavy with gravitas, the sleepy absurdities of hat justice found their stage. The case of Wiggins versus the People's Haberdashery was one of those sleepy spectacles that blurred the line between fashion critique and courtroom farce. You slip into a creaky woodland seat as the plaintiff, Miss Beatrice Wiggins, takes the stand, her towering hat almost scraping the courtroom chandeliers. Her complaint that the hat purchased from the People's Haberdashery, a flamboyant concoction of teal ribbons, crimson feathers, and a questionable wax bird, had caused her social humiliation when a judge at the Spring Cotillion commented publicly that the hat was vulgar and too large for polite company. Miss Wiggins claimed emotional damages, accusing the store of selling offensive millinery designed to provoke insult. Historians still argue whether this case was a sincere attempt to defend personal dignity or a sleepy satire of Victorian vanity. Either way, the court, by now well-versed in hat-induced drama, rolled into its well-rehearsed rhythms. The courtroom transformed into what the papers dubbed the Great Hat Fashion Parade, with the defense calling upon a parade of hat makers, society ladies, and fashion columnists to weigh in on the hat's tastefulness or lack thereof. One particularly sleepy moment came when the judge himself asked to try on the offending hat, donning it with such theatrical solemnity that the gallery burst into barely contained giggles. He concluded that while the hat was certainly a bit adventurous, it was not, by legal standards, obscene. You smile into your scarf as the testimony drifted into debates over hat proportions, the symbolism of feather arrangements, and the delicate etiquette of indoor headwear. The gallery, packed with fashion enthusiasts, treated the proceedings more like a catwalk than a trial, snapping fans and whispering critiques of the hat stitching. A fringe tidbit from the trial that continues to amuse sleepy historians involves the court artist, whose courtroom sketch of the hat wearing the judge rather than the judge wearing the hat became an instant sensation in Fleet Street's penny papers. In the end, the court dismissed the case, suggesting that taste, unlike laws, was a slippery, sleep-inducing beast best judged not in courtrooms, but at supper tables. You let the soft murmurs of the disappointed plaintiff and the chuckles of the gallery wash over you like a gentle tide. Because in the world of Victorian London, justice might have been slow, silly, and hopelessly tangled in hats, but it always rolled on with a drowsy dignity that soothed even the most outlandish grievances. And as you drifted out into the cooling twilight, your breath puffing into the lamplit air, you knew that somewhere another hat would spark another sleepy trial, another parade of yawning witnesses, and another chance to let the soothing hum of absurdity rock the city into the softest of slumbers. You meander now toward the inky alleys behind the newspaper offices of Fleet Street, where the scent of fresh ink mingles with stale coffee and the endless rustle of scandal sheets being stacked for th. In morning rush, it was here that the hat trials, however absurd, found their most enthusiastic chroniclers. In the case of Bumbley versus the illustrated gavel asterisk, the courtroom itself became the defendant. You squeeze into the gallery as Mr. Horace Bumbley, a pompous solicitor known for his glossy stovepipe hat and even glossier ego, took on the very satirists who had turned his hat trial into a citywide punchline. Mr. Bumbley, you learn, had once sued a neighbor over a misplaced bowler. But what truly outraged him was the depiction of his trial in the illustrated gavel asterisk, where artists rendered him as a waddling duck in a lopsided hat, presiding over a jury of sleepy pigeons. His claim that such vulgar lampoonery had undermined his career, dignity, and ability to command proper hat respect in his own law office. Historians still debate whether this case was an early battle in the war between public figures and the press, or simply another act in London's sleepy theatre of self-important legal absurdities. You, nestled into a crooked pew at the back, suspect it was both and neither. The satirists defended their work as public education in manners through gentle ridicule, prompting the judge to stifle a chuckle behind his robes. The gallery, packed with sleepy journalists and caricaturists, erupted in muffled snickers as the court was forced to endure a parade of sketches, each more ridiculous than the last lawyers depicted as puffed-up peacocks, jurors as napping sheep, and judges dozing behind piles of toppled hats. One fringe tidbit that tickles you drowsily: the defense introduced as evidence the gavel's latest edition, where the judge presiding over the case was portrayed as a sagging hat stand. The judge, to his credit, observed the sketch, adjusted his own hat, and murmured, "A fair likeness, I suppose." In the end, the court ruled against Mr. Bumbley, declaring that satire, however sleepy or cruel, remained beyond the reach of London's sleepy hat laws. Mr. Bumbley, fuming and hat perched defiantly, stormed from the courtroom, straight into the waiting pens of the gathered artists, who quickly immortalized his tantrum in ink and verse. You drifted along Fleet Street, the city's sleepy pulse lulling you deeper into its cozy rhythms. The penny dreadfuls, always eager for a sleepy spectacle, kept the hat trials alive long after the courtrooms had emptied, their sketches and sleepy poems ensuring that no crushed hat or wounded ego would be forgotten. And you let the sleepy nonsense of it all lull you into a soft, dreamy haze, the sleepy hum of the press wheels becoming your lullaby as you drifted deeper into the comforting absurdity of a city where Eve, in satire, wore a floppy hat. You find yourself, at last, on a quiet lane just behind Lincoln's Inn, where the ivy curls like sleepy ink-brown weathered stone and the footsteps of barristers echo with a kind of measured, yawning precision. This is where London's legal machinery slows to its most soothing pace, and where our final tale gently unfolds not as a trial, but as an invitation. You pause outside a modest courtroom where the woodman doors creak open like the cover of a very long, very drowsy book. Inside, the jury benches are half empty. The clerk is already nodding off, and the magistrate, it seems, has misplaced his spectacles and is pretending not to mind. This final case, well, it's yours. You're seated quietly, second row from the back, watching the slow unfurling of the courtroom like a warm cup of tea in legal form. This is the jury of lost toppers, a whimsical inquest into the city's strangest hat cases, now presented as a kind of sleepy ceremonial review. No stakes, no winners, just stories retold in the soft velvet hush of closing time. One by one, the hats reappear, not physically, of course, but in the minds of those present. The stolen topper from St. James's, the rain-soaked bonnet of Lady Constance, the pigeon-pummeled beaver felt, they prayed through your memory, each with its own sleepy scandal and softly absurd moral. The judge, spectacles finally found, recites the stories aloud as if reading fairy tales for grown-up children who never quite outgrew their fondness for polite nonsense. The jury, you among them, listens without judgment, letting the familiar cadence of Victorian absurdity settle like a warm fog. Historians still argue whether this sleepy court ever really existed or whether it was merely a shared dream among those too fond of stories and too tired to question the details. Some say the courtroom only appears to those willing to believe that justice, at its drowsiest, is a kind of lullaby in robes. You shift on the bench, your hat sliding forward slightly, your eyes growing heavy as the magistrate drones on about the legal implications of bonnet ribbons tied in public fountains and whether hat pie NS should be classified as concealed weapons. The court scribe, half asleep, forgets to dip his quill and begins doodling curls in the margins. The galley hums with quiet sighs. Someone somewhere snores. Even the judge seems less interested in verdicts now, more intent on winding down the proceedings with one final anecdote about a lost cap that turned up 30 years later in the solicitor's chimney. You smile. You've been part of this sleepy justice parade from the beginning, drawn through the fog and feathers and farce, and now, here at the end, you find yourself drowsy with satisfaction. The judge raises a hand more out of habit than necessity and gently declares, all hats accounted for, case dismissed. And with that, the courtroom sighs. The doors of the courtroom close softly behind you, not with a bang, but with a gentle click that echoes like a bookmark pressed between the pages of a story nearly forgotten. The gas lights flicker low now, casting long, golden shadows over the worn wood and quiet cobblestones. You step back into the fog, into a London that's just a little quieter, a little softer than before. The hats are still out there, of course on hooks, under beds, lost in hedges or drifting somewhere above the Thames on a forgotten gust of wind. But for tonight, they've found their peace. And so have you. The footsteps of barristers fade into the hush of twilight. The voices of angry plaintiffs and sleepy judges dissolve into the mist. Only the stories remain strange, pointless, beautiful, and they settle into your thoughts like down feathers in an old quilt. No one really cares who won the cases. The victories were always beside the point. What mattered were the rituals, the language, the comforting repetition of a system willing to take even the most ridiculous grievance seriously, as long as it came with a properly tied cravat and a reasonable sense of timing. And now, in the gentle silence that follows, you can finally rest. Let the fog wrap around you. Let the cobblestones soften beneath your feet. Let the last story slide like a satin ribbon through your fingers and into the night. Because the court is adjourned, the hats are home, and so are you. End of script. Sweet dreams.